Research case study by Francine Weigel. The parties in the case, New York Times v. Sullivan, are L.B. Sullivan, whose job included police commissioner, and the New York Times newspaper. On February 25, 1960, some African-American students from Alabama State University attempted to patronize the snack bar at a local courthouse. After their arrest, Governor John Patterson demanded their expulsion. Other students from Alabama State University marched in protest. Members of the KKK attacked the protesters. Newspapers ran photos with clear facial shots of some of the members of the KKK. Yet the police arrested no one. To draw attention to this injustice, civil rights activists took out an ad in the New York Times. Sullivan felt that by attacking the police in the ad, it defamed him, the police commissioner. Alabama defamation law at the time did not allow for any factual errors. There were several errors in the ad. Martin Luther King Jr. was arrested 4 times, not 7, and the song sung while protesters marched was the Star-Spangled Banner, not My Country 'Tis of Thee. There were also other factual errors. When Sullivan requested a retraction, the New York Times asked him why he thought the ad was about him. Sullivan asserted that not only were the facts misrepresented, but people would assume he was the Southern violator, and the police because he was the commissioner of the police. He was able to prove some of the misrepresented facts, such as the police, when deployed, did not ring the university campus. He had people say they would not hire a person responsible for the accusations in the ad, but none of those people said they believed he was that person. Finally, he did not prove actual malice or that he had suffered financial loss. In the original case, the judge did not instruct the jury about having to prove malice. The judge told the jury that defamation per se implies malice. Before this decision, defamation was a state issue. It was not considered covered by the Constitution. New York Times v. Sullivan determined that political speech, even defamation, is a protected constitutional right. The Supreme Court also held that the First Amendment rights extend to advertisements. In his opinion, Justice Hugo Black insists that allowing politicians to sue over political discourse is unconstitutional. The court concluded that facts can be accidentally misrepresented. Thus, a public figure must prove intentional misrepresentation of facts and actual malice. Sullivan did not have enough evidence of intentional misrepresentation or malice. He was also not able to prove the accusations were about him. In Gertz v. Welch, Elmer Gertz was an attorney hired by a family whose son was killed by a Chicago police officer. The Supreme Court determined Gertz to be a private person. His job as an attorney did not make him a limited purpose public figure. Robert Welch was the leader of the John Birch Society and publisher of the American Opinion magazine. He was accused of defaming Gertz. Welch published several statements that he did little to research or confirm. The article accused Gertz of giving false testimony against the police as part of a communist plot. The magazine also asserted that Gertz was a Leninist, communist fronter, and an officer in the National Lawyers Guild, which participated in planning an attack on the Chicago police at the 1968 Democratic National Convention. Gertz was also accused of being a leader in the Marxist League for Industrial Democracy. The magazine editor did not confirm these allegations. Some of the facts were partly correct at best or complete fabrication. In the article, the editor included a declaration that facts were researched and placed a picture of Gertz with a libelous statement about his communist participation and harassment of Officer Nuccio. This article, printed in the 60s. McCarthyism occurred in the late 40s and 50s. Adults reading this article were most likely the children watching the McCarthy trials and participating in nuclear bomb drills in school. Some people may have experienced PTSD or renewed fears from the article. This would lead to public shunning and loss of business for Gertz. In all cases I've read and studied this week, the most damning issue in every case was a lack of verification of facts. The second would be a stubbornness to retract and apologize for misrepresented facts. I would put aside my desire for a viral story and verify the facts. If anything did get by that turned out to be incorrect, I would be sure to retract and, if necessary, apologize. In Georgia, defamation, unprivileged, or false reports, regardless of format, require publication. Damages are slander that accuses one of committing a crime, malicious accusations that affect one's livelihood, asserts one has a contagious disease or has committed debasing acts, and other comments that allow for special damage compensation. A plaintiff has 1 year to file a claim from the defamatory occurrence. Private citizens must prove damages, falsity, the publisher is at fault, and the statement is about them. Public officials must also prove actual malice. However, there are times when a private person becomes a limited-purpose public figure. Since mistakes happen, Georgia does not consider a single instance to be defamation. Georgia is a per se state. Some acts do not need proof of damages. Opinions are libel if they do not appear to be an opinion. Georgia awards actual monetary and other damages as deemed necessary by the court. You can choose the right or follow the golden rule, but at the end of the day, we all have our faults and biases. Always confirm facts, especially facts with potential to damage reputations. My pride and biases must always be in check. As the saying goes, just because you can do something doesn't mean you should. I will always consider my motivations and verify facts before printing.